this session is going to focus largely on arbitration, and I'll just quickly share my screen so that we can go through the slides that I have for today. Okay, again, let me just clarify, because we got about, I think, 2 or 3 questions from people. The first session that we had yesterday, one of the speaker, made reference to the fact that parties cannot draft agreement without a lawyer. And I know a lot of people asked questions yesterday as to whether when you are drafting an agreement, you need a lawyer before you can draft an agreement, or whether parties cannot draft an agreement without involving a lawyer. And we got questions after the session yesterday, follow-up questions on, relating to that, position. So just to clarify that parties are at liberty to draft agreement, enter into the agreement, and execute such agreement without a lawyer. And we see that on a routine basis. Particularly in the music and entertainment industry, they typically don't involve lawyers. Even for some SMEs, because the legal fees may be somehow too high or prohibitive, and because of that, they decide to just, enter the agreement or draft the agreement themselves. So it's fine if, party A and party B are going to enter into a contract and they decide to come up with a draft of the agreement and sign. There's no law that stops parties from entering into a contract and drafting up that agreement themselves. But what the law prevents or prohibits is for a third party or for someone to draft an agreement in return for a financial gain, which is what we call the practice of soliciting, right? For contracting parties. So someone that is not qualified to be a lawyer drafting an agreement in return for a financial gain for the parties, and that is absolutely prohibited. But there is nothing that stops 2 contracting parties from drafting the agreement themselves and moving on with executing it and moving on with it. The only concern is that if you are not versed and not qualified to draft such an agreement, which we see, like I made reference to music and entertainment industry, at the end of the day, there are lots of issues that will come up that you still have to go back to a lawyer. So why would you not just use the lawyer in the first place? Well, I think that sufficiently clarifies it. If there are other questions, I'm happy to answer them. Now, moving quickly, as you see from your screen, the outline for today, I'll provide a quick background of what arbitration is, the types of arbitration, and the basic understanding around core principles in international arbitration, which you will see on a day-to-day basis if you are involved in arbitration. I'll also provide responses, clarify some issues, some knotty issues which you may have encountered. I'll provide some basic model clauses, model arbitration agreements, so that you see what an arbitration agreement looks like, and also do a summary of some of the key takeaways for us today. 1 second. So as you see from the slide, the course is to introduce participants to some of the key principles and pillars of arbitration, which have contributed to the success of arbitration as a preferred dispute resolution method. And this I will try to contextualize for us as SMEs. And at the end of this session, I'm hopeful that you will be able to describe the importance of arbitration. You understand what arbitration is, the key principles and pillars of arbitration or international arbitration. You'll also be able to explain arbitration practice and procedure and how they are useful for SMEs, and also understand drafting and negotiation of arbitration agreement as it relates to your respective businesses. Now, yesterday, in my opening remarks or welcome address, I referred to some surveys and empirical analysis that have been done in relation to disputes. And this is just to provide context background for us, for us to understand why this session is really important. Why are we putting SMEs, bringing them together in Ghana, in Nigeria, in Mozambique? Why are we concerned about disputes to SMEs? So there are some disputes that, by their nature, they are very strong. They are very, the cost of the dispute or the sums or claims involved, are so high that they can kill the business, right? So imagine you go into a contract and someone has sued you to court and is claiming millions of naira from you, and that in a way may impact your business or operating costs. So what I try to do is to look at surveys, that have considered the impact of disputes on SMEs. And as you see from your screen, you see that the annual dispute costs, or of dispute to SMEs, by an independent survey that was conducted in the UK on the SMEs in the UK, says an annual dispute cost of 13.1 billion is spent on by SMEs on disputes every year in the UK. Also, another independent survey by Escalate Survey says that 96% of SMEs in the UK regularly experience commercial disputes. So dispute is something that will come up on a routine basis for us as SMEs. And the focus of this training is to be able to help us to sidestep some of the difficulties that we may have, and also help us in managing our businesses very well in such a way that we either obviate that dispute or find a way of managing the dispute in an efficient and effective way. So I also looked at the data in relation to the global value of dispute generally, and what the figures are showing is that a whooping sum of 86.86 billion US dollars is spent on generally on arbitration in a year, and 13 arbitral institutions, administering institutions, share these 86 billion disputes. We have the LMAA. LMA is the London Maritime Arbitration Association, the International Chamber of Commerce, and other arbitral institutions. They all are the administering dispute that have administered these 86 billion US dollars. See how much of money is spent on disputes annually, particularly in relation to arbitration. So the first question before we go deep into this is, how familiar are we with arbitration? Who is familiar with arbitration? Who is not familiar with arbitration? I will do a quick poll now so that I have an understanding of how many people are familiar with arbitration. Tell me, can you launch the poll now so that we see how many people are familiar, how many people are not familiar with arbitration, so we understand from the beginning. Can you launch the poll?
Yes, I have.
So if you can see the poll on your screen on your phone, just click on the one that you are familiar with. So if you're familiar, just click you're familiar. Not so familiar, maybe you just heard about it before. And if you are very familiar with it, just say you are very familiar. So we have an understanding from the beginning. So I'm going to vote now. So we'll just allow about 1 to 2 minutes to allow us vote. Okay, I think most of us should have voted now. Temi, can you launch the result of the poll? Okay. So can we all see the result? So about 35% says they are familiar with arbitration, 62% says they are not so familiar with arbitration, and 8% says they are very familiar. So for the benefit of those that are not so familiar, which is the 62%, I will try as much as possible to simplify things. Tell me, you can close the poll now to simplify things, and try to also moderate it in such a way that I'm still at the level of those that are a little bit familiar with it. So what is arbitration? Arbitration, as you can see, and I've tried to explain it in a simple way, is a formal and consensual submission of a dispute to one or more arbitrators for a decision to be reached. I've tried to explain the difference between arbitration and mediation, or arbitration and negotiation. I said negotiation and mediation, they are informal process. parties coming together to discuss amicable settlement of their disputes. But because there's no formality to the process, the settlement agreement, can be disavowed at any time. Parties may not comply with the settlement agreement. So arbitration came up as a formal process outside the courtroom, in such a way that you have something that is akin or similar to your court judgment that you can enforce, and parties are not able to rescind or disavow at any time. So arbitration is a formal and consensual submission of a dispute to one or more arbitrators for a decision to be reached. So at the heart of this, explanation or definition are two things. One, formal. So what is the formality around it? Formality means, and we'll be going into this in the course of on other slides. Formality means that there must be an agreement, an arbitration agreement that will be drawn by the parties that expressly refers to arbitration as the dispute resolution mechanism that has been agreed by the parties. Consensual submission means parties must expressly consent to arbitrate or submit their dispute to arbitration. We say submit the dispute to one or more arbitrators, meaning that you can either have a sole arbitrator or have 3 arbitrators to determine the case. So I've also put some other elements that the process is only contractual and based on the arbitration agreement. As a matter of fact, you cannot do arbitration without an arbitration agreement because parties must agree to arbitrate. Otherwise, then the dispute will have to be settled by the court. And why is that important? It's important because ordinarily the state through, the court operates through is as a mechanism of the state, right? So, which is the process by which traditionally disputes are settled. So, for you to say the court should not administer the dispute or should not decide the dispute, parties must consent. Laura said yesterday when teaching us speaking on law on contracting, she referred to offer and acceptance as an agreement, forming the bedrock of a contract as an agreement between the parties. So it's the same way an arbitration agreement, operates. So the parties have come together. One is making an offer, another person is making an acceptance that their dispute be settled by way of arbitration. How does it offer? How does it operate in practice? So it can be by sending an email to say, oh, wow, we are going into this contract, but do you think that our contract should be settled by way of arbitration? And the other party agrees that, okay, yeah, we don't want this dispute to be tied up in court. The court process is unduly long. The cost, is quite high. So because of that, let's do arbitration. And parties agree. Once they have that agreement, then parties reduce that, into writing. So an arbitration agreement is the bedrock of the arbitration process. Without the arbitration agreement, then the arbitration process you cannot do arbitration, right? Then it's also private. Private means that it is outside the court present. Parties can arbitration. Sometimes I sit as an arbitrator, and sometimes you sit and you do arbitration proceedings even in hotels. You can do it anywhere. It's private. It's also confidential. As a matter of fact, reasons why some people prefer arbitration is the confidentiality of the process. Because once you, for example, your traditional litigation, when you have a dispute and you file your case in court, that whatever you file in court becomes public because anybody can go to court, tomorrow to make an application to court to get a copy of the court process or documents that have been submitted in the case. So if SME A and SME B are into a particular contract relating to say production of a particular goods, and that production involves trade secrets, involves some other things, merchandising, that you don't want people to know about, right? But at the time you file your case in court, there must be disclosure. And once you disclose all those things in court document, it becomes a public record that anybody can apply for, can have access to at any time. So parties may also prefer arbitration because of that confidentiality of the process, because arbitration is just simply between party, the SME A and SME B, and the arbitrators in a private, private setting. So arbitration, so another an inquisitive observer, and that applies to those that have said they are familiar, very familiar with arbitration. They can ask that Abayomi, this is arbitration can also be under the BIT or MIT, and I will explain what that means, and not necessarily under contractual agreement. Yes, that is true. But for us as SMEs, what concerns us is, arbitration agreement under a contract. But so that you also understand that uh, arbitration do come up to under BITs. What are BITs? BITs are bilateral investment treaties. When foreign investors are coming into a country and they want to come to that country to do business, it is important to them to know whether there is a bilateral investment treaty between the country of that investor and the investment destination, the host country where that foreign investor is going into. And typically, what a bilateral investment treaty does is to state, two countries are coming together to, have discussions or agreements around protection of investment by citizens or businesses in their countries. So, if, for example, Nigeria has gone into a BIT, bilateral investment treaty arrangement with Canada, is to protect investors in Nigeria that are doing business in Canada and Canadian investors that are doing business in Nigeria. And essentially, it says there will not be expropriation. The properties and the businesses of the investors are protected. There will be fair and equitable treatment, and so many clauses in that bilateral investment treaty. But as part of that BIT framework, it's also the dispute resolution clause, which typically stipulates arbitration as the dispute settlement mechanism. But I don't want to go too much into that so that I don't conflict things. So, but for us, what we need to know at this stage is that arbitration is only contractual and is based on an arbitration agreement. Uh, I've also stated that tribunal is able to negotiate and impose cost on parties. Okay, so if, for example, you have a case in court, when you go to the court registry, what you do typically is, and for some of us that follows our lawyer to court when they are filing, or you've gone to file yourself, when you get to the court, you go to the court registry, you submit your papers to the court registrars. They do an assessment of your papers and they tell you how much to pay. Sometimes it can be ad valorem, sometimes it's the fixed cost, and of course, you dare not argue with them, otherwise you'll not be able to file your papers, right? So uh, then so at that point, you are bound to follow what you are being, or the cost that has been imposed on you, by that process. But arbitration is different in a way because the process can be negotiated either with the administering tribunal. I see that Fumi Yaya has joined us and she will be introducing us to institutional arbitration, particularly under the Lagos Chamber of Commerce International Arbitration Center, LATSIAC. So you're able to negotiate with the tribunal, as to cost, that you will incur in that in relation to that proceedings, as against when you go to court and the costs are actually fixed. Another feature of arbitration that is that decisions of the part of the tribunal are typically binding. I've said that what distinguishes arbitration from mediation and negotiation is that the binding nature of the outcome of the process. Unlike negotiation and mediation or other parts of ADR that results in settlement agreement, which parties can decide not to follow or disavow. Once the outcome of an arbitration process is an arbitral award, which is final and binding on the parties and is enforceable in a similar way like a court judgment. So that is why some people refer to it as a quasi judicial process. Now, moving further, 1 second. So some of these things I think I've mentioned in terms of the element of arbitration. I said consent. Consent means that parties must agree to arbitrate, and this can. So I think I need to explain this. So when you say consent of parties or agreement to arbitrate, there are two types of arbitration agreement. It can be an arbitration clause in a contract, and it can also be a submission agreement. And I'll explain the difference between both of them. So when SME A and SME B are going into a contract of supply, and SME A is to supply goods to SMEB, and SMEB is to supply, to pay for those goods. Essentially, that is reduced into writing. And I've said that as part of that agreement or the contract is an arbitration clause, or you call it a dispute resolution clause. And in your dispute resolution clause, you have stipulated arbitration as the dispute settlement mechanism, right? You said when there's a dispute or when a dispute has arisen between the parties, parties will settle their disputes by way of arbitration under the rules of arbitration or the rules of the Lagos Chamber of Commerce International Arbitration Center. That means parties have opted for arbitration, right? So that is an example of an arbitration clause. So when you insert arbitration agreement into a contract, pre-dispute, dispute has not arisen. Parties are just going into a contract, but they foresaw or foresee into the future that in the event that there is a dispute that will arise in the context and in the course of this relationship, we want that such future dispute to be settled by way of arbitration. Then is an arbitration clause. But when dispute has arisen and parties, maybe for one reason or the other, they did not insert an arbitration clause or dispute resolution clause, and we see that on a routine basis. I've reviewed some agreements for clients that they will not even have governing law clause, they will not have dispute resolution clause. Sometimes you find out that maybe they did not involve a lawyer, or they just stated their understanding, and of course they have an agreement. So the question that you ask is, can there be arbitration post-dispute? That means when dispute has arisen, can parties still agree to do arbitration? Yes, that is possible. That is what we call a submission agreement. So where parties have not, prior to the dispute arisen, parties have not submitted to arbitration. After the dispute has arisen, parties can still decide or agree to arbitrate. And that is what we call a submission agreement. That means you are submitting your dispute to the arbitration process. So the difference between arbitration clause and submission agreement again is one is pre-dispute, which the arbitration clause is pre-dispute and it looks into future dispute. Submission clause is post-dispute, meaning it's used after the dispute has arisen and it looks back rather than looking forward. Then I've also said present and future dispute, private persons as decision maker. I've said, okay, let me expatiate on this. Now, one of the benefits of arbitration is that you are able to select your arbitrators. So in your agreement, you typically have an arbitration agreement that says, in the event that the dispute has arisen between the parties, parties will settle it by way of arbitration under the Lagos Chamber of Commerce International Arbitration Center by a sole arbitrator, or by an arbitrator, by a tribunal of 3, or by 3 arbitrators. Now, when is a sole arbitrator? How does he operate, right? So the 2 disputing parties will have to come together to agree on who the sole arbitrator will be, who the person will be to administer that dispute or to sit on that dispute. If parties have agreed on 3 arbitrators, what it means is that party A will appoint 1 arbitrator, party B will appoint another arbitrator, then the 2 arbitrators will now appoint the 3rd arbitrator who will be the chair, over the tribunal. So where parties are unable to agree on the appointment of arbitrators, right, then they can apply to court under Section 7 of the arbitration law. We call it the Arbitration and Conciliation Act, for the court to appoint an arbitrator for them. But what's the importance of that appointment process? The importance of it is that parties are able to decide who will be the adjudicator over their dispute, unlike the litigation process. And I'm trying to draw a distinction in the course of this session between arbitration and litigation, so we begin to understand the importance. In the normal court, traditional litigation, once you file your case in the registry the same way I've described the other time, once that case has been filed, the next thing that happens is that the judge that is presiding over that court will assign to a judge. And once that case is assigned to a judge, you have no choice. You have to go before that judge and submit yourself to that judge, or your lawyer will submit to that judge and do your case. So you have no participation in the appointment process, in a court, in a traditional litigation. But in an arbitration process, parties are at the driving seat. They decide who becomes the arbitrator over their disputes. And the person does not need to be a lawyer, because I think that's the next question that will be asked. Someone asked it yesterday that when Sheila spoke on mediation and negotiation, is it compulsory that the mediator should be a lawyer? No. The same thing with arbitration. It's not compulsory that an arbitrator should be a lawyer. As a matter of fact, in the arbitration space now, we have lots of accountants, engineers, that are into the arbitration practice, and parties do go for those arbitrators sometimes, because when there's a technical dispute that requires technical expertise, sometimes you may want to apply to appoint such technical expert as your arbitrator. So that is just the point to note, the takeaway for us on that. And I've also discussed that the process is the outcome is final and binding. If it is not final and binding, then it is not arbitration. Then there are different laws that are implicated, particularly where it's an international arbitration. You have what we call the choice of law rules, and the intersection of different laws. Well, I will not want to go to that. Like I said, I don't want to go into the legalist part of it. Now, just to summarize all the things that I've explained thus far in terms of differences between arbitration and litigation, advantages and disadvantages of arbitration. I've discussed this, but this slide, of course, brings everything together. The first thing is party autonomy. Party autonomy means that the parties are the driving seat. The parties decide who the arbitrator will be. The parties decide the applicable rules of procedure. The parties even decide where the seat will be, where the venue will be. Can you decide where the venue will be in the court case? If they assign your case to perhaps it's at the Federal High Court, and the case is before a judge in Owerri, even if you are living in Abuja, you have to fly down to Owerri to do the case, right? But for arbitration, parties are able to decide where the venue will be because they are at the driving seat. The next thing is that the parties also are able to control costs, unlike the court or traditional litigation where you have no control of the cost involved in that process. For arbitration, you're able to control costs. Confidentiality, I've also spoke about that to protect confidentiality, particularly where it involves trade secret, where it involves some sort of innovations, parties may not want to go to court, because once you're in court, all the documents and processes becomes public and anybody can have access to them. Then the fourth thing is parties. Sometimes parties do choose arbitration because of arbitrators' commercial experience or technical experience. And I've said in the arbitration space now, for example, in construction disputes, maritime disputes, people would rather go for maritime expert or construction expert or engineers or surveyors to be the arbitrators because of the technical experience, because they believe that those are the people that will be able to understand the context of the dispute very well and be able to decide them effectively. Then the procedural informality and the flexibility. Of course, the process is flexible because the parties control the process. Then time efficiency, right? When you compare litigation and arbitration, you see that even though arbitration recently now is becoming slower, but then when you still compare with traditional litigation, you see that it still has an edge, right? And why does it have an edge? You can decide to do arbitration. And I've done an arbitration, I've sat as an arbitrator in a case that I only sat, I think, 3 times. That's the fastest arbitration I've done since I started sitting as an arbitrator. We sat those 3 times. So to manage the efficiency of time, parties can agree to say, okay, we front load all our document on the arbitration, just do preliminary hearing, preliminary meetings, everything, put everything in, and the arbitrator will decide. So you're able to control that efficiency, the time efficiency. But in court, you have no control of the process. Your matters can be prolonged, and there'll be lots and lots of adjournment, or the judge may not sit, which is what we are used to now. And you can't control that process or control that the time efficiency, unlike in arbitration. Then the neutrality of the process, the likelihood of bias is very minimal. And why is it minimal? Because both parties control the process. So I've explained, for example, in a tribunal of 3, or arbitrators that are 3, party A appoints his own arbitrator, party B appoints his own arbitrator. Although what we see in practice is that once an arbitrator has been appointed by a party, they come to do that party's bid. They want to impress the party that has appointed them. But generally, there's supposed to be independence and impartiality of the arbitrators, such that once they come together as a tribunal, they are supposed to look at the dispute dispassionately without any form of bias and to render their award in good time. So, what are the downsides of arbitration? Arbitration may not be ideal for all types of disputes, and I'll be in the course of the session, I'll be speaking to what we call the concept of arbitrability. What that means is that you may want to do arbitration, well, because of the advantages that you see on the left side of your screen. But if your dispute is such that it is not amenable to settlement by way of arbitration, then I'm sorry, you may not be able to do arbitration. And under that concept of, or under that slide, under the concept of arbitrability, I'll be speaking to some of those disputes that may not be amenable to arbitration. One that comes to mind quickly is criminal matter. So a criminal matter, for example, is not arbitrable. Tax matters, Nigerian law, though in some jurisdiction, tax disputes are arbitrable. But in Nigeria, tax disputes are not arbitrable. In fact, there is a case of Start Oil and NNPC, FRS and Start Oil involving Shell and other multinational corporations, in relation to payment of petroleum profit tax and royalties, where the court has said in that case that you cannot settle by way of arbitration. Anything that relates to tax must be settled by court. So tax disputes and also no arbitration. And there are other disputes like that that they are not amenable to arbitration, whether by virtue of what the way the court has decided or looked at them, or maybe the law simply says don't do arbitration. This can only be done in courts. Then increasing costs. The way arbitration was established when it was initially formed, was to save costs. The typical cost that you will have incurred in cost. Arbitration was to help to save those costs. So you can, like I said, I've done three proceedings where parties had to save lots of costs. But now we see that arbitration itself is getting more increasingly prohibitive, cost prohibitive. And I'll explain why. So you see rather now that in recent time that some arbitrators, some arbitration proceedings, particularly when they're international in nature, some may be held in Paris and parties will have to fly. I've done one arbitration that, involves government officials, and they have to fly, people in that government department, they have to fly all of them to Paris. They were in Paris in hotel for like about 3 weeks when the proceedings, were going on in Paris. And a lot of costs that were incurred by the party. So increasing costs now. But what is the difference between arbitration and litigation in relation to costs? Parties are able to manage costs in arbitration. Unlike in litigation, cost is fixed by the court. You have no control over costs. Then limited coercive powers of arbitrators. That's another demerit of arbitration. Now I'll quickly look at the Q&A box and see if there's any question. Someone has said that in layman terms, please, who is an arbitrator? Are they compulsory lawyers or who can serve as an arbitrator? Thank you very much. I'll quickly answer that. An arbitrator is an arbiter, a third party that has been given the power by the parties to decide their disputes in layman terms. So disputants or two disputing parties have said we don't want to go to court because we don't come back from court and become friends. And typically, so when people go to court, they don't come back and still do business. But people want to continue business, they want to retain the relationship. Because of that, they don't want to go to court. So yeah, you can settle your dispute in an informal way, and you still get an outcome that is as enforceable like as a court judgment. And that is why you go for arbitration. So an arbitrator in a layman terms is a third party neutral, third party arbiter that decides the dispute of the parties in a private environment, in a private settlement, under, as stipulated by the arbitration agreement. You have said who can serve as an arbitrator. I've said anybody, including you that you have asked that question. You can also be an arbitrator if you are rightly appointed by the disputing parties. Anybody can serve as an arbitrator. As a matter of fact, the concept of arbitration had lived with us or been with us, since long time. When in different communities, when there are disputes between parties, the chiefs or the heads of the communities will, come together, will sit as arbiter, and people will bring their dispute to them and they will settle it. That's informal arbitration or customary arbitration. So anybody can sit as an arbitrator once you are able to, assess the dispute and, render your judgment or your decision in an impassionate and independent manner. Next question by Sidikat Folami is, if an arbitrator is not necessarily a lawyer, how are we sure the ruling will be guided by law? Or will the arbitrator be guided by lawyers where he or she is not a lawyer? Fantastic question. Yes. What you typically see is that most arbitrators are lawyers, but not all arbitrators are lawyers, right? Why is that so? It is so because the practice of arbitration itself, is regulated by the law. The law that regulates arbitration in Nigeria is the Arbitration and Conciliation Act. So it just comes as a natural practice that for lawyers that are doing litigation or for lawyers that are doing commercial practice, they also understand arbitration and do arbitration. But that does not mean that a non-lawyer cannot be appointed as an arbitrator. So when there's a dispute and a non-lawyer has been appointed as an arbitrator, it typically in a tribunal, right? They will appoint at least a lawyer who will be able to guide them, as to the issues of law, and they can now appoint maybe one or two non-lawyers that will guide them in relation to the technicality of the dispute. So you have a mix of it. I'm sitting as an arbitrator in an international arbitration now that we have an accountant, as a member of the panel, and the two other arbitrators, the two of us are lawyers. So, but in unusual circumstances, you can also have an arbitrator, a technical expert who is not a lawyer, that is sitting as an arbitrator, as a sole arbitrator. In that case, the technical expert, technical person that is sitting, that a non-lawyer that is sitting as an arbitrator may invite a legal expert, to provide what we call an expert report, to guide that arbitrator in that dispute. So it depends on it's fact sensitive, it depends on the fact of the case. But yes, a non-lawyer can sit as an arbitrator and be guided by lawyers. Someone has said, okay, appreciate the slides. Yes, we'll circulate all the slides. You said, please, can you explain conflicting awards under downside? Yes, what conflicting awards mean is that, some parties are funny, right? So assuming that this is an arbitration between two parties with different nationalities, and one has commenced arbitration in a jurisdiction, another party can also, because it's a private process, another party can go and commence arbitration in another jurisdiction or in another setting. And with that, you have potential conflicting awards by two tribunals. That is a possibility because of the private nature of arbitration. That does not happen often, but it's a possibility. And because of that potential, possibility, that's why we try to flag this under downsides. But that typically will not happen. Then another person has asked that, can the venue of arbitration taken outside the country where the contract was signed? Absolutely yes, it means to do I. Where, for example, parties have decided to, for example, okay, I've done an arbitration, that involves government counterparties that, those government counterparties expressly chose venue to be in London or Paris because it just felt like maybe it's a way to go to London hotel and enjoy themselves after the proceedings, or something. So you have the liberty to choose anywhere outside of the place where the contract is signed. That is why we have party autonomy. It's controlled by the parties. You can decide to choose anywhere outside the locus of the contract, right? Another person has asked that, what does it take to be an arbitrator? Is there some kind of training? Absolutely yes. There are trainings that I will speak to at the end of this session so that you are properly guided in the event that you want to join us in the world of arbitration. Another person has said, how long do we try arbitration before resulting to litigation? Now, you have to be properly guided, and I'll be speaking to this under arbitration agreement. You don't first do arbitration before you resort to litigation. Both of them are independent processes. So if you have an agreement that says do arbitration and if arbitration fails, you resort to litigation, that agreement will be invalid. In fact, they call it pathological clause or pathological arbitration clause. I didn't want to go too much into that, so that I make it simple for us to understand. But arbitration must be, I've said it has to be final and binding. There must be finality of the process. So where you have resulted or you decide to do arbitration, that arbitration must be the final and the beginning and the end of the process. Because once you finish with your arbitration, you have your arbitral award. With your arbitral award, you can go to court, register that arbitral award as a court judgment. So you don't need to do litigation again. So you are not resorting to litigation after arbitration. Last two questions before I go back to my slides. Can foreign arbitrators be appointed for local cases? Absolutely, yes. I have arbitration cases that I'm sitting as an arbitrator, that other arbitrators are foreigners. The law allows them, the law does not prohibit foreigners from being appointed as arbitrators in local cases, but they cannot act as counsel. There's a case of involving Shell, I think Shell and NNPC, where the court has held that foreign lawyers or foreign people or foreign lawyers or foreign practitioners cannot act as lawyers in arbitration process or arbitration proceedings, but they can be appointed as arbitrators. I also sit as arbitrator in other countries, and I'm not qualified to practice in those countries, and I'm a foreigner. So there's no law that stops a foreigner or a foreign arbitrator from sitting as an arbitrator. Last question before I go back to the slides. When an arbitral award is given and dissatisfied parties go to court, get an injunction. Okay, I'll get to award later and I will explain this under award. Can a case in court be closed and reopened in arbitration? Yes. I will quickly explain this. So if parties have decided to do arbitration, party A and party B, SMEA is into farms, agro-allied product or farming. Party B is into supply of chemicals, and a dispute has arisen as to supply of the chemicals to the agro-allied company or farming company. And the dispute has arisen. When the dispute has arisen, one of the parties, instead of starting arbitration, has gone in defiance of the arbitration agreement, has gone to court to start a court proceedings. The law allows the other party that has that arbitration agreement, one of the parties to the dispute, one has gone to court, the other one has not gone to court. The law allows the person to come to court to say, court, we have an agreement that says when we have disputes, it will be settled by way of arbitration. This case should not be in court. So Section 5 of the Arbitration and Conciliation Act, and I've said I won't cite law, but that is the best way to explain it. Section 4 and 5 of the Arbitration Act, which is the arbitration law in Nigeria, allows a contracting party to come to court and say, file an application for the court to stay proceedings, in support of arbitration. What that means is that you tell the court, this is a case where we have signed an arbitration agreement. This case should not be decided by the court. And once the court sees the arbitration agreement and sees that parties have agreed to settle by way of arbitration, the court will stay that proceedings and refer parties to arbitration. That's the simple answer to that. I'll move quickly to other slides, then I will take your questions again. So, yes. So, another question by an inquisitive observer is, an arbitration agreement, should it be in writing? What are the formalities? Yesterday someone asked that, how do you enforce an oral contract during the session on contracting? That can an oral contract be enforced? Yes, you can enforce an oral contract. Question is, can there be an oral arbitration agreement, or must all arbitration agreements be in writing? And this, is not as easy as it appears on the screen, but I'll try to, simplify it, well. Most rules and most laws, as you find in the Arbitration and Conciliation Act, which is the arbitration law in Nigeria, as you find in the laws in most countries, say that I've said arbitration agreement must be in writing. And why is that so? It is so because parties are agreeing that we want the court to take the back seat. We don't want the court to decide our matter. So if you want, to prove that kind of understanding, it has to be in writing. So imagine if, for example, one of the parties had gone to, there is an oral arbitration agreement, and one of the parties had gone to court. When you go to court, you go and tell the court to stay proceedings in aid of arbitration. What will you demonstrate to the court? You have to bring the arbitration agreement to the court to show to the court that, see, my lord, this case is a matter for arbitration, we should not be in court. So simply what that means is that arbitration agreement must be in writing. As common law, and when we say common law was, when we were colonized by the British, there were some laws that we inherited from the British, then written and oral arbitration are allowed. But now, as the current practice in most countries, in most jurisdictions, is that arbitration agreement should be or must be in writing. And I've tried to bring out some of the relevant laws. You can read them up later. Um, the element of the formality of of an arbitration agreement. What someone would ask is that when you say in writing, what does it mean? Does it mean that the arbitration they must use pen and paper to write it, or kind of if they have an exchange of or maybe communication by emails, can it also constitute in writing for the purpose of formality of an arbitration agreement? And I've tried to bring it out what the law recognizes as constituting in writing for the purpose of an arbitration agreement. And I've said it can be in an exchange of correspondence, which provide a record of the arbitration agreement. So where party A and party B, the MD of party A has, sent an email to the MD of party B, say, well, these are contracts. Should it be settled by way of arbitration? And the other party has agreed. That can be an arbitration. That can be a valid arbitration agreement for the purpose of arbitration. It does not need to be a properly drawn agreement. It can also be exchange of correspondence in an email. Okay, so what are the kinds of arbitration that we have? I think I've spoken to arbitration clause and submission agreement, and I'm sure we still understand. I said arbitration clause looks at future dispute, is typically in the contract. Submission agreement is when the dispute has arisen. So, for example, you are listening to this, you are part of this session, and you are listening to this training now, and you feel like, wow, there's a dispute that I have with a particular company. Why will I not? I seem convinced by this training by this young professor. Can I? Why can't I just settle this dispute with this person by way of arbitration? And the question you're asking me is it still possible because your contract does not stipulate arbitration? Yes, it's possible. After the dispute has arisen, you can have a submission agreement to submit your dispute to the arbitration process. Now, I've also tried to bring out a standard arbitration clause, and the one that was easier for me to get was the standard ICC arbitration clause. Fumi Iyayu will be speaking to the LASIAC arbitration clause, and she will also show to you an example of an arbitration clause under the LASIAC rules. That is the Lagos Chamber of Commerce International Arbitration Center. But this is the one by the International Chamber of Commerce, and this is how arbitration clauses are typically drafted. It says all disputes arising out of or in connection with the present contract shall be finally settled under the rules of the arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the rules. So, what are the elements of this clause? All disputes arising out of or in connection with this present contract. What does that mean? It's looking at future disputes, right? It says settled under the rules of the arbitration of the International Chamber of Commerce. What does that mean? It's specifying the procedure that the parties want to guide the process, the arbitration process. It says by one or more arbitrators appointed in accordance with the rules. By one or more arbitrators. What does that mean? Meaning it's looking at the appointment of arbitrators, those that are going to settle the dispute eventually. So that is a typical, and it can be broader than this. It can be as short as 4 or 5 lines, and it can also be as long as 5 or 6 paragraphs specifying the seat of the arbitration, the language, the venue, and some other key elements of the arbitration clause. Now, quickly, let's move to an arbitration agreement, just to look at arbitration agreement deeply because it's very important. Most of the cases that we have today that have challenges with, that they have 1 or 2 challenges in relation to arbitration, is the arbitration agreement that usually have, concerns. So it is important if you are going to be doing arbitration, if you are going to be opting for arbitration, that your arbitration agreement is carefully drafted. In fact, effectively, efficiently, carefully, whatever word you can use, drafted. You must pay attention to the drafting of your arbitration agreement so that those you won't begin to have issues, when the dispute has arisen. And what we typically advise is that you can use a model clause like the one that I just showed you, or like the one that Fumi will show you shortly. On just use that kind of clause, or just speak to your lawyer. Or even when your lawyer has drafted the clause, still look at it to be sure that it is what you actually want. So quickly looking at the arbitration agreement, it must arise out of the mutual consent of the parties. What that means is that parties must agree to arbitrate. There is mutual consent, there is consensus, addendum, or there's meeting of minds between the parties, so one party is not being forced or being coerced to do arbitration. Second thing is parties must have legal capacity, like Laura said yesterday when she spoke on contracting. One of the key elements of contract is capacity of the parties to enter into legal relations and to contract. So parties must have legal capacity. Agreement must be made in writing. I just spoke about in writing. Must arise out of a defined legal relationship. The subject matter must be arbitrable. And shortly, I'll be speaking to arbitrability. This is in writing, what constitutes in writing under the New York Convention. You have that to read later. I will just keep that so that I'll move to some other things. Then this is arbitrability. Now, I've said that it's not all disputes that are amenable to arbitration. So before you draft your agreement and you put arbitration, you have to know carefully whether that agreement itself is one that is, amenable or can be settled by way of arbitration, right? So disputes submitted to arbitration must be arbitrable. There's some subject matter dispute, like I said, criminal issues, tax, even trademarks and patents are not arbitrable, although in some jurisdictions, you can also arbitrate trademark and patent, right? But in Nigeria, I've not heard of any trademark and patent case that has been arbitrated. So there are some disputes that are not amenable to arbitration. Check carefully that the subject matter of your dispute is one that can be settled by way of arbitration, right? That is the concept of arbitrability. The next thing is competence of the arbitral tribunal. What does this mean, right? Someone has said, asked a question that when we do arbitration, do we still have to go to court, right? No, you don't have to go to court because the same power that the court has, the power the arbitrators also have. Although maybe court may have something that is slightly more, right? And I'll try to, disaggregate this. So for arbitration tribunal, the law, and if you check most laws of different countries, imbues those arbitration tribunals with the power to do a lot of things, a number of things. One of it is to decide the competence of their power. So if, for example, one of the parties is challenging the competence of an arbitral tribunal's power to sit over a dispute, so, some people will say, oh, because I'm challenging your power, you cannot decide it yourself. I have to go to court. If the court says you have that power to sit on this dispute, then we'll come back. No, the arbitral tribunal has the power to decide his own competence. So you submit that dispute to arbitration. The tribunal will look at it and see whether he has power to determine that dispute or not. If he says he does not have power, then you can go to court. But if he says, oh, well, this dispute is one that is within our competence, then they will continue with it and write their award. So what this means, we call it competence. That means an arbitrator or an arbitration tribunal has the power to decide its own competence. So when there's a challenge to the competence of an arbitral tribunal or to the power of an arbitrator, he is the first person to decide that, not that you rush to court and ask the court to determine it and come back. No. So that is what we call competence or competence of an arbitration tribunal. And I'll move quickly. Then also I thought to flag what we call concept of separability or autonomy of the arbitration agreement. And what does this mean? What it means is that, I've explained the concept of having your arbitration clause in your agreement. And if you remember Laura's session yesterday, we said a contract will have three main parts, right? If you can remember, part one is the introductory part of it, your recital and the other introductory part. Part B, or second part, is the operative part, which stipulates the obligation of the parties, supply, demand, whatever is the core of the agreement or the arrangement. Then we have the part C, which is the boilerplate clauses, where you have your severability, waiver, governing law, dispute resolution. There are some other things, that you have, that are not necessarily at the core of I want to buy or I want to sell. But they are also very important because they either stipulate how the dispute between the parties in relation to that agreement to be settled, or they allocate risk. That's why they are also important. We call them boilerplate clauses. So imagine your dispute resolution clause that has an arbitration clause. arbitration clause is what I've shown you, like this, something like this. Yes. So imagine your agreement that has a dispute resolution clause that says all disputes arising out of our supply agreement, right, shall be finally settled under the rules of the Lagos Chamber of Commerce International Arbitration Center by one or more arbitrators appointed under the rules. This is an arbitration clause. There is a concept that we call separability. This separability means that the arbitration clause has its own independent life and it is separate from the main agreement. What that means is that you can disaggregate and take your arbitration clause from if you take it from that agreement, right? The other agreement can survive on its own, then the arbitration clause can also survive on its own. What is the effect of that? The effect of that is that in the event that the agreement, the totality of the agreement is invalid or for any reason is unenforceable, that will not affect the arbitration clause in that agreement because it has its own independent life. That is what we call separability or autonomy of the arbitration agreement. And what is the further effect of that? The further effect of that is that where there is an agreement that says supply XYZ, right? And when there is a dispute, it will be settled by way of arbitration. That's what the agreement says. So assuming that the agreement is unenforceable, the supply agreement is unenforceable, right? The question is, will the further agreement to settle by way of arbitration, will it also be unenforceable? The simple answer is no. What that means is that the arbitration agreement will still be live. And what that means in effect is that to determine the unenforceability, to determine the validity of the main agreement itself, it will be by way of arbitration. So the arbitration agreement will survive the questions, any question relating to unenforceability or validity of the agreement. So what that means is that when there is a question in relation to validity of an agreement, that question does not affect the arbitration agreement. You can disaggregate it, take it out, and what that means in effect is that any dispute in relation or question in relation to validity of a contract, the arbitration agreement will survive it, and the dispute can still be settled or the question resolved by way of arbitration. If that is not clear, then I can go over it again, but I'll quickly watch my slides. But right now, let me look at the questions that we have. Yes. Or who bears the cost of arbitration? Yes. Cost of arbitration is borne by the parties, by the two parties typically, and this can be jurisdictional, right? And I'm explaining this because I don't have any slide on cost. So normally each party is supposed to bear its own cost, but there are some jurisdictions that cost follows the event, or cost follows the. What that means is that cost follows the winner will not pay cost. The winner means that the person that has triumphed, is successful in the case, will not pay cost. The loser pays the cost. So it can either be in some jurisdiction, or each party will pay its own cost, or it can either also be, the loser will bear the cost of the proceedings. And typically in arbitration, the arbitrators have the power to allocate costs. So they can decide to say, okay, well, each party will bear its own cost. Looking at this dispute is one that we think each party should bear its cost. And they can also look at it and say, well, this is one that, but for the fact that this man has started these proceedings, this other party will not have incurred costs. So the losing party should pay the cost of the successful party. So they can now allocate costs as appropriate. Another question is, can a case in court be closed? Okay, I think I've answered that. Then says, please go over it again. I couldn't comprehend it. Yes, so don't worry. Arbitration, for me too, I did it at in master's level 10 years ago. I also did it at PhD level. So some of these concepts can appear a little bit technical, but I'll try to break it again. So the concept of separability, and this is important for us, so that we'll know when lawyers come and speak all these, they are typical big English, competence, separability, and they are outstanding and they are asking for big money. Just call them and say, my professor has taught me this separability, I understand it, and I know what you're saying. And what this means is that there is a contract, assuming it's a supply contract. That supply contract has different clauses. Recital, the operative part of it, which says Party A will supply, party B will pay an amount of money or some sums for the supply. Then you go down, you have other clauses in the contract. One of the clauses that you have in that contract is the clause called dispute resolution clause. That's your dispute resolution clause. What it means essentially is that it specifies the nature or the dispute settlement mechanisms that will be adopted by the parties when dispute has arisen. Now, the concept of separability means that that dispute resolution clause is separate and independent of other clauses in the agreement. Meaning that if there's any question relating to the validity or unenforceability of other clauses in the agreement, the dispute resolution clause will not be affected. So any question related to that validity will still be settled by way of arbitration. So where you have had an arbitration clause that says any dispute will be settled by way of arbitration, assuming there is no concept of separability, what that means is that the whole of the contract falls flat, and even your agreement to arbitrate will not be binding anymore because it will be unenforceable. But because of the concept of separability, it disaggregates and takes an arbitration clause or agreement, makes it separate and independent of the other clauses in the contract, such that any questions of independence, validity, or unenforceability of the main contract, the arbitration clause will still survive that question, and the dispute or the questions can be resolved by way of arbitration. If you, for the sake of time, if it's still not clear, I'm happy to provide some sort of clarification by email or by phone. Then stages of arbitration. This is very important. What are the stages of arbitration? How does it start? So assuming the dispute has arisen between the parties, what will the parties do? The first thing is, so assuming SME A and SME B, they have a supply contract, the dispute has arisen, the aggrieved party is SME A, right? The aggrieved party serves a notice of commencement of dispute on SME B that, the contract, the eggs that you supply to us, or the breads that you supply from your bakery, they were bad and they were not fit for purpose. So because of that, we couldn't use them. So we demand some sort of compensation or indemnification from you. So they serve the other party with a notice of commencement of arbitration. What that does essentially is that arbitration is about to begin. So when that notice is served, on party B, the question is, what does party B, what does it do? Party B will look at the notice, will see the dispute, the summary of the dispute that party A has stated in the notice. Then party B will file his response. So it's the same way you file your court process, that a claimant goes to court or plaintiff, file his case, they serve on the defendant also responds. The same way here, you serve your notice of commencement of arbitration on the other party, on the counterparty responds. In your notice of commencement of arbitration, you will have included in that notice what we call, a request for appointment of arbitrators. What that does is, so I've explained that there are two ways of appointment, as in two appointment types. It's either you have a sole arbitrator appointed by the parties, or you have a tribunal of three, where party A will appoint one, party B will appoint one. The two arbitrators that have been appointed will come together and appoint the third arbitrator, who will be the chair. So assuming the case that we are talking about now, the case in reference, the contract in reference, as just a sole arbitrator, right? So when the party A, that the aggrieved party, is serving his notice of commencement of arbitrator, it will include in that notice that this dispute provides for a sole arbitrator. We are nominating Abayomi Okubote as the arbitrator in this case, and they will now request the counterparty, which is party B, to also either confirm that appointment or provide a list that both parties can now look from that list and agree on who will be the arbitrator. But assuming that the agreement references three arbitrators, that means party A will appoint his own and stipulate and state in that notice of commencement of arbitration who he has appointed or is recommending or is nominating. Then party B will also respond. In its response, will also state in it who is nominated arbitrator is. And with that, the two arbitrators, they will communicate to them. After they communicate to the two arbitrators will meet. And I'll just explain this with one of the arbitrations I'm doing in Egypt, in Cairo. So, one of the parties appointed me, and after I was appointed, I got in touch with the other arbitrator, who is an Egyptian arbitrator, and we had a discussion on Zoom. And we said, okay, who do we appoint as the third person? Who will be the chair? So we said, okay, let's give, because both of us are male, let's appoint a woman or a female so that we have a balanced tribunal. Let's appoint someone that is not from our countries. So I don't have to appoint another Nigerian or appoint another Egyptian from another country, possibly in Africa. And we came up with the criteria for appointment of the third party. And we provided a list. So I provided a list of 3 people from Tanzania, from Ghana, from Kenya, and they also provided this list. And we had a discussion. And we streamlined to 2 people, then we now streamlined to 1 person. And we communicated with third person whether the person was free to join us as a member of the tribunal, and the person confirmed. And that was how the arbitration tribunal was composed in terms of the composition. So moving to the next one, in terms of composition of the tribunal, that's how it is composed. Party A nominate or appoint, party B appoint, then the two arbitrators come together and appoint the third party. The next thing after composition of the tribunal is, now that the tribunal has been formed, what's next? Next thing is the parties will file pleadings similar to what you file in the court proceedings. You file your pleadings. Pleadings means that your papers, your processes, you file those processes where party A is alleging, the aggrieved party is alleging breach. You will file a process that shows that breach and attach relevant documents. Party B that is disproving that breach will also file his case, his papers, and attach documents to show that is not guilty or liable to damages, or is not liable to breach, or the breach was not occasioned by him. It can also rely on any other defense like force majeure. So assuming that is a contract, that could not be performed because of COVID-19 pandemic, and party B is relying on, well, my non-performance is because of force majeure that I'm not able to perform. So party B can also rely on any other defense, whatever defense you are relying on, you put it in your pleadings and file your pleadings. Next thing is there's what we call a preliminary meeting. What is preliminary meeting? What does it do? A preliminary meeting, what it does is that, sorry, someone is saying, I can't hear the speaker anymore. Hope this has been corrected. And if you cannot hear me, maybe you can sign out, log out, and log in back. So after the pleadings have been filed, and it is very important for you to understand this process as SMEs, so that lawyers, well, I'm a lawyer and I want to, of course, we want to make money, but you understand, even if it's not about reducing the fees that you pay your lawyers, it's also important for you to understand the process so that you're able to follow through. When your lawyer is not doing something right, you also know that, okay, this is how the process runs. So when the tribunal has been composed, next thing is filing of pleadings by the parties. After pleadings have been filed, then we have what we call a preliminary meeting. A preliminary meeting is the first meeting where the tribunal will come, will sit as arbitrator, and it's always very informal. It can be in a hotel, it can be in an arbitration center, and they'll just sit down, very, very informal setting. We just have maybe 3 chairs in front. They sit down with the table, and you have the parties sit down in front of them, and they'll have discussions about how the arbitration will run. That is what we discuss at the preliminary meetings. So we have issues relating to when are other documents going to be filed, what will be the language of the proceedings. So assuming it's an international arbitration that I am from Nigeria, another arbitrator is from Egypt, and maybe he only understands Arabic. The third arbitrator is from Mozambique and can only speak Portuguese. So we can agree on the language of the arbitration to be English, and parties will speak. What that means is that parties will speak English and file their processes in English. But for the tribunal that are not, they don't understand English, they can get like interpreters to be interpreting to them in the course of the proceedings. So it is at these preliminary meetings that we set out all the procedures and conclude on have agreement on how the arbitration will run. Then the next thing is discovery. What does discovery mean? When parties are filing their pleadings, they put the relevant documents in the pleadings. They attach the relevant documents. But there may be some important documents that one of the parties has not attached. Then it's at this discovery stage that the party that wants to rely on that document will file an application so that the party that is in uh, custody of the document can provide or bring it before the tribunal. The next thing is hearing or taking of evidence. Now, there's something about this hearing that I will speak on shortly, which is what we call virtual hearing, because hearing can either be physical, which is the way we have always been doing it prior to COVID-19 pandemic, and it can also be virtual, which is what we do now when the pandemic has started. So right now, I'm presently in Toronto, Canada, and I've sat as arbitrator on several disputes in Nigeria, in Cairo, in different places, even since I arrived Canada. And what that means is that because of COVID, we are able to do virtual hearing. So hearing can either be virtual and it can also be physical, right? But it is at the hearing stage that you take evidence, you call all your witnesses, and evidence is taken. Then once evidence has been taken, parties will file what we call post-hearing briefs. Those post-hearing briefs are to summarize all the things that have happened in the proceedings and to make canvas argument on why the claimant should be entitled to the claims he's seeking or the reliefs he's seeking, and why the defendant or respondent should not be liable to the claims against him. So you have your post-hearing submissions, right? Then the tribunal will now come back. So right now, I've done some proceedings that they've submitted post-hearing briefs, and some of them can be as big as 500 pages with lots of documents. So after that post-hearing briefs, tribunal will give themselves time to go through the processes again, all the documents that have been filed by the parties. Then we'll now write what we call an arbitral award. What is an arbitral award? The same way you have your judgment, after hearing has been done, and the court will say, well, this case is reserved for judgment. Although most times those judgments will not come until after 1 year or 2 years. But in arbitration, we don't do like that. Once we've done post-hearing submissions, next thing is we settle down, we meet as arbitrators, we agree on how we think the award should go, how to allocate risk to the parties, who should be the successful party in the case based on the evidence and the case that has been before us. And then we go into writing. Or for sake of a proper arrangement or guidance, typically the chair of the tribunal will produce the first draft of the award and circulate to the other tribunal members for them to make their own contributions. And once they make their contributions, you have your final award. And there are circumstances or instances, although it has not happened to me in my over 10 years of doing arbitration, that some arbitrators one or two arbitrators may not agree with others. So assuming it's a panel of three, one may dissent and say, well, I don't see this the way you are looking at it, and may decide to write what we call a dissenting opinion. But typically in an arbitration, the outcome is an arbitral award that will be written to decide the case, to adjudicate on the case, similar to what you have in as a court judgment. Then after the award has been done, the question is, Professor, what is the next thing after an arbitral award? What do? Do you keep the arbitral award in your office, or what next? Next thing is to take that arbitral award because it was rendered or issued in a private arrangement, even though recognized by the law. I've said there's an Arbitration and Conciliation Act that recognizes this award as being final and binding on the parties. But you still have to take it to have that enforcement mechanism to be able to use the apparatus of the state to enforce it. You have to take it to court. So the law allows you, the Arbitration and Conciliation Act allows you to bring that the arbitral award to court and register it as a court judgment. Once you register it as a court judgment, then you can have your judgment certificate, which of course you can get the bailiff of court or the sheriffs to help you enforce. But after an award has been done, the same way you are able to go to court to enforce it is the same way the losing party, can also come to court and say, this award, court, don't enforce it. And this is it's the part of the arbitration process that people used to say, brings up the bad things about arbitration, right? Because At the point where a person is still able to say, court don't enforce, that may be the beginning of another case or another prolonged litigation. But I will speak more on recourse against arbitral award and enforcement in subsequent slides. So quickly, of course, arbitration is very wide, very technical, but I hope I've been able to take us on a journey that all of us are able to follow through. Then, I've mentioned virtual hearings. I've said that right now, given the COVID-19 pandemic, uh, virtual hearings are now commonplace. That's what we do now. I can't remember prior to COVID, right? If we have a hearing, we travel to Paris, to London, to Vienna, to New York. We travel everywhere to sit as arbitrators or as counsel. We travel to attend proceedings. But since the pandemic started, what we've done is we could not just simply wait. We don't know when the pandemic will be completely, the restrictions will be completely off. What we did was to, fashion out ways by which those hearings can be conducted virtually, either on Zoom, on Microsoft Teams, or any other virtual hearing platform. So virtual hearing is possible. We now do our hearings virtually. And what I've thought to do with this slide is to explain, in summary, what virtual hearing means and how it operates. What are the key elements or the essential things you need to know in virtual hearings if you're so interested in it. One of it is due process. That means proper notice must be served where you are doing virtual hearing. The other party, so if one party wants to do virtual hearing or the tribunal wants to do virtual hearing, you must give proper notice to the parties so that parties can prepare, their virtual hearing platform. Maybe you are using Zoom and the person does not have the infrastructure, for Zoom or software. They can get all the necessary things. Now, another thing is equal opportunity to present their case. There must be what we call it virtual equality or due process. So there must be due process. All the parties must be, considered. So, if, for example, one party is in Japan, the other party is in Nigeria, there is time difference. So, for example, now I'm in Canada. For this training, I had to wake up at 4 a.m. For this training, and that 4 a.m. was already about 9 a.m. or 10 a.m. in Nigeria. So, assuming a tribunal that is fixing hearing time for 4 a.m. Canada time, it may not be convenient for parties that are in Canada. So, you consider time zones, you consider accessibility of internet and infrastructure. These are some of the things that you consider when you are opting for virtual hearing. Next thing is arbitral award. I've spoken about arbitral award before, but I just thought to expatiate on it. The arbitral award, there's a requirement that it has to be in writing. It has to be in writing and be communicated to the parties, and it has to be final in nature. So what it means is that when you say final, is that it must treat all the issues that have been submitted to the arbitral tribunal. So the case of party A, the case of party B, the arbitral award must treat all of them. Otherwise, that arbitral award will have problem, and it can be basis for setting aside that award. The arbitral tribunal is required to state the reason for the award. Similar to a court judgment. In a court judgment, for those that are familiar with court judgment, you will know that when you are reading the court judgment, the court will typically say, the basis for these findings is X, Y, Z. The reason for this finding is X, Y, Z. So for arbitral award too, there's a requirement that you must state your reasons for any findings that you are making. It's the same way you use what you are familiar with or what you see in judgments. And then an arbitral award shall be signed by the arbitrators. There's a requirement for signature of the arbitrators to confirm who the arbitrators are. The arbitral award, I've said that one of the benefits of arbitration is confidentiality. So arbitral award will be confidential. It does not need to be made public. But if, for example, you are taking it to court for enforcement, that one, then it becomes public. But some people don't even go to court for enforcement of award. Once that arbitral award has been issued, the other party complies with it. And you see that in some of these multinational companies, Shell, Texaco, they have lots of agreements that they do on a day-to-day, on a routine basis. So when there's an award, in relation to a dispute between those big corporations, they typically just comply. They don't go to court. So the reason may be because of the confidentiality of the subject matter of the dispute, or just to move forward with other, commercial arrangement that they have, they will typically just comply with their word and move on. So to protect the confidentiality, you may not need to go to court for enforcement. But of course, once you go to court and you register it as court judgment, anybody can go to court and apply for CTC of that award, of that judgment. Then I've also said that the party relying on an award, in terms of the enforcement. So when you want to take your award to court for enforcement, what is the procedure? The procedure is that you take an authenticated original award or a certified copy. How do you do certification? You take it to a notary public to certify for you as duly authenticated copy of the original. So you take that to to court for registration. You also take the original arbitration agreement or a certified copy of it. These are the three things that you take to court: the arbitral award and the arbitration agreement. And why is the arbitration agreement important? The court will look at the arbitral award and see that this award is an award that is coming out of an agreed arbitration process. So both parties, because some people do Jankara practice. I don't know how to translate Jankara for people that do not understand that. What it means is underhand practice. So what they do is, they will go and start arbitration without putting the other party on notice. They will get an arbitral award and they will come to court to come and enforce that award. So the court will have to look at the award and ensure that there was an arbitration agreement. The parties, both parties were given equal opportunities. They submitted to the tribunal's jurisdiction, and that award, both parties, award is coming out of that agreed arbitration process. In that regard, then the court will go ahead to enforce it, as the judgment of the court. Next thing is, if you want to set aside your award, what are the things that you need to do? I have it on the slide so that I can allow for me to come and take a session. But then just a quick recap of all the things that we have discussed. We have said that due to the formality and the prohibitive cost of litigation, SMEs should take advantage of the arbitral process by including arbitration clauses in their contract. Arbitration is the way to go now. If you want something that is formal, something that is binding in nature, by all means, it is better than court process. It is cheaper than court process. It is time efficient than court process for an arbitration that is properly managed. Then SMEs should pay attention to the arbitration clause in their contract and the person they get to appoint as the arbitrator and counsel. So if you want to do arbitration, make sure that when they are drafting your contract, you see that it's a properly drafted arbitration clause, right? And I've said, if you are not sure, look at sample or template arbitration clause that we have provided for you in the course of this training. Look at them again, or you can even come to us, call us and say, this arbitration clause, do you think is fine, the way it has been drafted? And we'll advise you. So you also pay attention to who you are appointing as your arbitrator. Make sure the person has the relevant experience, not necessarily a lawyer. Some people like us, we have legal background and we are also arbitrators. I can also appoint someone that is an arbitrator that is not a lawyer. But make sure that the person is someone that can decide the dispute in an efficient way, has a requisite experience to handle that dispute. Then the person, or whether even as counsel, make sure that it's a counsel that can handle the case well, does arbitration. And why this is important is that the fact that someone is a lawyer does not mean that he can do arbitration well. There are so many court or traditional litigators that we have in, for example, a place like Nigeria, that what they do well is litigation, court litigation. They typically don't do arbitration well. But when they come to arbitration, they want to use the same process, the same style they use in court for arbitration, which most often don't work. So try to get proper arbitration counsel. Again, if you are confused or if you have any concern, you can always call us for help. So arbitration may be considered as a mix with other ideal process. Yesterday, Sheila spoke about med-arb, or with other forms. What does that mean? What it means is that you may decide that, okay, before we do the formal process of appointing arbitrators, going into the full arbitration, fully blown dispute resolution process, why not let's first try negotiation or let's try mediation? So that is what we call med-arb. Med-arb is where you have decided to do mediation first, and if mediation does not work, you do arbitration. That's med-arb. Then you can also have negotiation, neg-arb, which is you first do negotiation. If parties are not able to settle the dispute after the negotiation process, then you do arbitration. So it can be a mix of mediation and arbitration, negotiation and arbitration, a mix of the ADR processes. And SMEs must devise means of managing their dispute efficiently to ensure business sustainability and profitability. This cannot be overemphasized because, see, the essence of this training is because we know that cost of litigating, we know that cost of running all these legal issues can affect the profitability of the business or sometimes kill some businesses. So for business sustainability and profitability, it is expedient for imminent for SMEs to always look at your contract, be sure your contracts are well drafted, you get good lawyers to draft them. Don't use templates from other things that you have done in the past and just go and copy and paste. It's when you have problems that you know that paying small fees to a lawyer to draft it for you will have saved you all this trouble. So make sure your contracts are properly drafted. If you want to do arbitration, make sure you appoint the right person, you get right advice from the right lawyers. Like I said, we are always ready, start and well positioned to help you if you have any concern. So before Fumi comes up, I'll just look at the Q&A box and see whether I'll pick one or two before I'll hand over to Fumi. Next one is Mr. Ryobu Onyekachi. I said I should explain ODR. Well, fantastic one. ODR. So the virtual hearing that I just explained is is a nucleus or a part of ODR because of the virtual nature. So ODR is online dispute resolution. That's the full meaning of ODR. What does that mean? What it means is you are settling your dispute online. Simple terms. Now, ODR was initially or essentially set up for resolution of consumer disputes. So you have Jumia, you have eBay, all those online platforms where you buy things. They have the process for by which their disputes are settled, right? So, for example, if you have a dispute with eBay in terms of you order something on eBay and the goods are not delivered or something happened, you cannot be suing eBay to court because eBay will not be able to cope with all people suing them from different jurisdictions because of that supply or delivery. So eBay, like Jumia and all those online platforms, they've designed ways by which that dispute can be settled effectively, which is what we call the ODR. So initially it was set up for consumer-related disputes. Just set up that is a mechanism. We have ODR, different ODR platforms where you can go, and I think LASIAC also have something, I think on ODR, where you can go, register your disputes there. For some of them, like eBay, they already have registered ODR platforms that you can just go put your complaints there. Someone will look at those your complaints and make the necessary decision, in relation to that dispute. But nowadays, we've now seen that with the COVID-19 pandemic, ODR is now expanding beyond what we call the C2C dispute. C2C is consumer to consumer dispute. It is now moving also beyond business B2C. Which is consumer business to consumer dispute. It is also now expanding to what we call the B2B and the G2B. What that means is it's now expanding to business dispute, and it's also expanding to government to business disputes. I can provide further clarification on that maybe after Fumi's session, but I will allow her to take a session shortly. One more question. Someone is saying, what are the benefits of arbitration? You will see these, flexibility, cost saving, party autonomy, all these you see on the slides. We'll share the slides with you so you can get it. Our employment contract to be drafted by lawyers as well. Yes, I've said that. See, parties are at liberty to draft their contract themselves. So if an employee and an employer wants to go into a relationship and they say this our contract, they pen it down. So, for example, I as an employer, now I want to engage a new lawyer to work in my firm. I can decide to come up with a draft. Okay, assuming I'm not a lawyer, so because you can still say I'm still a lawyer. So assuming a party wants to employ an SME wants to employ an employee, you can come up with a small agreement, a template, maybe a one pager, and send to that employee to read through and agree to the terms. and that will become the employee agreement between the parties. Nobody says that will be drafted by a lawyer, but what the law prohibits is for someone to draft an agreement in return for, as in with in return for a financial gain. So if it involves getting financial gain for that agreement that you have drafted, that is work of a solicitor. You are doing the work of a solicitor, and the law does not allow that to be done except you are a qualified lawyer in Nigeria. Last question. I would like to contact you to go over an MOU on agreement. Okay, I think that we can discuss that on a personal basis. Um, can I still call for arbitration even though the person has come for an informal settlement? Of course, I've just explained to you, Ms. Sidikat, for allowing me that. See, we can do different types of a mix of the AGR process. You can do med app and neg app. So for negotiation, for this what I've described now in terms of informal settlement is possibly a negotiation process or mediation process. So if the parties are discussing settlement in an informal way, that's fine. Once that informal way, concludes and you are not able to agree, then you can start arbitration. But you have to watch carefully and be sure that there's an arbitration clause in your agreement. If there is none, both parties can still submit to arbitration by drawing up what we call a submission agreement. At this point, I'll close the curtain.